My name is Stephanie Gillespie, and I am a librarian, not a copyright lawyer. Chances are neither are you, but you can still understand and follow copyright law when preparing for your classes. In these short videos and documents, I'll go over some of the relevant points of copyright for you, including Creative Commons licenses, copyright coverage, fair use, guidelines for classroom copying, the TEACH Act, getting permission, further reading, and Pellissippi resources. In this video, we'll go over the basics of copyright law, including who is an author, what are creative works, and which rights do authors and users have. Copyright law protects creative works that are fixed in a tangible medium, such as a computer file, a CD, or a canvas. Copyright does not protect ideas, methods, slogans, logos, symbols, discoveries, data, or facts. However, ideas, methods, slogans, logos, and discoveries may be protected either by patent law or trademark. Things that are not copyright protected but possibly under trademark or patent protection are Just Do It by Nike, Apple's logo, Berlitz language learning method, or climate data gathered in the Arctic Circle. Copyright law tries to balance the rights of the author and a creative work and those of its users or purchasers. Much of the law defines who an author is, what a work is, and what exactly the rights are of authors and users. Please note that copyright law is different in other countries, and works are governed by the country of its origin. Who is an author? You are the author of your work, except when, if you are an employee and create a work during your employment, your employer has the copyright. If you sign a contract to create a work for commission, such as a work for an anthology or a test, the commissioning entity has the copyright. If you sell your copyright to the work, the buyer then owns the copyright. If you give up part or all of your copyright to the work, it falls into part or entirely into public domain, which we'll talk about more in the Creative Commons licenses. Now, at this point, you may be wondering if your course materials, academic articles, and lectures are considered work for hire. Unless your contract specifically states that the academic institution owns your course materials, or if you are specifically assigned to develop course materials for the academic institution, you own them. In the online space, the Digital Millennium Copyright Act has put these long-held practices into question. To make a clear distinction, Holmes and Levin from 2000 recommend posting your course materials onto a private service provider such as Google Drive or Dropbox, which you can link to from the course website, just to make that clear. So what is a creative work? Any work that's not purely factual. Factual works include items like spreadsheets of statistics or phone book. Creative works can include stories, plays, poetry, music, software, art, dance, and architecture. Copyright only protects tangible expressions of a creative work, like a recording, written document, or a file on a computer. It does not protect facts or ideas, although ideas can receive patent protection. However, the wording of the facts and ideas is protected by copyright. So, what are the rights granted by copyright? The author has the right to copy the work, make derivative works based on the copyrighted work, distribute copies of the work by sale, rental, lease, or lending, publicly perform the work, publicly display the work, which includes posting or embedding it online, but linking is a different thing. Publicly perform the work using digital audio transmissions. Now, if users buy a copy of the work. They have the right to make copies of the work for personal use. So this is like you upload the CD to iTunes. Resell the copy of the work. Privately perform the work, for example, at a personal party. Privately display the work, for example, in your office or at home. Next, we'll talk about Creative Commons licenses.